in this live with their stupidity. Make sure una block. Ngoja kwanza niweke sticker. Where is the sticker? Wow. Sawa, nimeweka sticker. Now, I'm going to read for you the evidence that made Kanyari akakuwa convicted in the lower courts. So, this being a first appeal, it is the duty of this court to reconsider and reevaluate the evidence adduced and the submissions made in the trial court so as to arrive at its own independent conclusion. In so doing, this court is required to always bear in mind that it is neither saw or heard the witnesses as they could testified and must therefore give due allowance that in that regard. See Okeno to Republic, 1972, EA 32. The court is making references as to why they must respect anything that is submitted in terms of evidence. The prosecution submits, and the prosecution case can be summarized as followed. On December 6, 2017, the complainant, PW3, PO, was playing with other children. When the appellant, who was known to her as Pastor Kanyari, and the court has quoted his name as quote unquote, Kanyari's name has been put in quotes in court. Okay? So, as Pastor Kanyari called her to his house. He told her to remove her skirt, which she did. Thereafter, the appellant removed his own clothes and then he inserted his penis into her vagina. She cried due to the pain that she felt. After finishing, the appellant told her to go outside and play with her friends, but she went straight to her house. PW3's mother, PW1, IN, returned home later that day and found her seated at the door. A neighbor, known as Monica, passed by and informed her, PW1, that PW3 was walking abnormally. Kanyari alibaka mtoto mpaka alikuwa anatembea abnormally. Alibaka mtoto mpaka mtoto hangeweza kutembea vizuri. The neighbor noticed the child walking abnormally, and the neighbor named Monica was a witness in this case. Mnasikia? Walking abnormally. As such, PW1 took PW3 to the house and demanded to know why, whereupon PW3 told her that Pastor Kanyari had defiled her. PW1 examined PW3's private parts and she saw dried semen in the outer parts of her vagina. She immediately reported the matter to their village elder known as Mataka. The village elder informed her that the said Pastor Kanyari, in quotes, was well known to him and advised her to take PW3 to hospital for examination and treatment while he worked on causing his arrest. The appellant was arrested at around 6 a.m. on December 7th, 2017, and PW3 was able to identify him. Okay? As the Pastor Kanyari who defiled her. He then was escorted to Naivasha police station where PW1 reported the incident. Thereafter, PW1 was issued with a P3 form which she took to Naivasha District Hospital for filing. The matter was investigated by PW4 number 613C396 Corporal Otuke, formerly stationed at the Naivasha Police Station. He recorded statements after interrogations and visited the scene of crime. He also conducted inquiries around the village and ascertained that the appellant was also known as quote-unquote Pastor Kanyari, also known as Pastor Kanyari, during the trial. He produced both PW3's birth notification, which shows that she was born, the baby that Kanyari Alibaka was born on May 17th, 2013. Further, PW2, Benjamin Kuria, a clinical officer from Naivasha County Referral Hospital, testified on behalf of his colleague, Faith Wanjiko, who examined PW3 but was away on leave. He stated that the medical examinations, which include on genital examination, PW3 had blood oozing from her vagina, okay? And her hymen was broken. He also stated that the examination medical officer concluded that PW3 had been defiled, and in view of the aforesaid revelation, he produced the PW3 post-rape care form and P3 form filled on December 7, 2017. A post-rape care form is different from a P3 form. A post-rape care is the one that brings out the DNA evidences and matching from Pastor Kanyari's DNA to that one of the child. Because they tested the semen that was dry plus the blood that was oozing, and they found a positive match to Kanyari's. The appellant gave a sworn testimony in his defense. He testified that on December 6, 2017, he was in the house the entire day. The following day at 6 a.m., he had people asking whether he was in the house. He went outside and met two men who escorted him to the village elder's office. On their way there, he was assaulted by members of the public. Kanyari was claiming he was assaulted by members of the public. He was then arrested and taken to police station, where he was charged for the subject offenses. Analysis and determination. The appeal was canvassed by both written and oral submissions, which this court duly considered. The only issues for determination are: 1. Whether the appellant constitutional rights were contravened during trial, whether the prosecution proved its case beyond reasonable doubt. Whether the appellant constitutional rights were contravened during trial, I'm going to read that to you. The appellant submitted his constitutional rights to a fair trial was violated. In this regard, he faulted the trial magistrate for failing to inform him of his right to legal representation at the state expense Article 50 of the, as the state explained under Article 50 of the Constitution. So Kanyari was complained that he was not explained to by the system at that time that he had a right to legal representation. That is one thing that he complained about. Further, he complained that the prosecution furnished him with a charge sheet and statements prepared in English language, but the trial court did not bother to find out whether he understood the language well enough to enable him to defense or challenge the evidence. Kanyari was saying that he was presented with evidence and paperwork written in English, and apparently he did not know how to speak and understand English. So they did not consider that he doesn't know English. That's what the court document is saying. These were his defenses, okay? On the other hand, learned state counsel for the respondent submitted that the appellant was promptly supplied with the relevant statements and documents that the prosecution relied on, and did not at any point inform the trial court that he had a problem comprehending the case against him. Counsel also asserted that the appellant never raised the issue of legal representation before the trial court, and appeal were well versed with it. He was well versed with the case. So legal representation is a constitutional right envisaged in under the Article 52GH of the Constitution, which provides as follows: every accused person has a right to a fair trial, which includes the rights to choose and to be represented by an advocate and be informed of right promptly, to have an advocate assigned to the accused person by the state and the state expense if substantial injustice would otherwise result, and to be informed of this right promptly. It also provided for, it is also provided for under the Legal Aid Act 2016, Section 43, of the Act requires that an unrepresented accused be promptly informed of his or her right to legal representation. Further, Section 43 of the Act provides that where substantial injustice is likely to result, an unrepresented accused person should be promptly informed of the right to have an advocate assigned to him or her. I have carefully perused the trial court record, and at no point during the trial did the learned magistrate inform the appellant of his legal rights outlined above. Was this fatal to the trial? I did not think so. By the way, this is the judge talking, not me. Was this fatal to the trial? I did not think so. This is because Section 43, legal aid, clearly stipulates that the lack of legal representation cannot be the continuation of proceedings against a person unless substantial injustice is likely to occur. See also Republic of Karua Chongo and others, 2017 EKLR. The judge was quoting a case. The question as to whether substantial injustice may occur depends on the circumstances of each case. In determining this, Section 43 of legal aid requires the court to take the following into consideration: the severity of the charge sentence and the complexity of the case. Sawa sawa. Now we continue. This is the judgment now. The capacity of the accused to defend themselves. Now this is Kanyari being told by the court that the grounds that he brought were not, substantial. And so he was being quoted for cases in point where if he needed legal representation, he should have asked for it. It was not on record that he asked for it, and it was not given to him. Everything was read to him. He was aware and very well conversant with the case. And so whatever issues he was raising were irrelevant and were not substantial enough for them to proceed and feel like his rights were violated. So now we go to the next part, where whether the prosecution proved its case beyond reasonable doubt. This is the part. Section 8 of the Sexual Offences Act provides following regard the offense of defilement. A person who commits an act which causes penetration with a child is guilty of an offense termed defilement. In determining this offense, the court is required to consider whether the prosecution proved the following ingredients to the required standard: penetration, age of the victim, and the positive identification of the appellant and the perpetrator of the offense. Did you hear that part? The age of the victim and the positive identification, which means the medical records needed to identify positively that what they found in the medical records of this child, including the DNA tests that were done on Kanyari, plus the semen and the blood that was using, was supposed to match. So this is what the court found, that there was a positive match. Okay? As regards to the victim, PW4 produced in evidence a birth notification which shows that the PW3 was born in May 17, 2013. Now that is evidence number 2 that shows that that was a minor. That was a minor that was born in May 17, 2013. It was therefore undoubtedly proven that PW3 was age 4 years old and 6 months at the time of the alleged offense. And she was thus a child as per Section 2 of the Children's Act Cap 141 of the laws of Kenya. As regards to elements of penetration, the appellant submitted that the medical evidence tendered by PW2, as Mia says, since PW2 did not state his qualification, that of Faith Wanjiku, who prepared the P3 and post-rape care forms. Further, he argued that the PW2 did not tender good reasons for Faith's failure to attend court, and this to unjustly deny him an opportunity to cross-examine her on the medical evidence. According to the prosecution, however, penetration was conclusively proved. So Kanyari was trying to say that the lady who was not present, that he wanted to cross-examine her, so she was not present, and that is reason enough for him not to believe what was presented. This is now the magistrate talking, the judge. In my view, in PW's 3 account of alleged defilement was well corroborated by the medical evidence tendered by PWT, which shows that she had blood oozing from her vagina on examination of her genitalia, and her hymen was severely broken, which led the examining doctor to conclude that she had been defiled, and it was unusual for a person of her age. Further, I note that during the trial, the appellant did not raise the complaints he is purporting to raise now about the medical evidence, and neither did he object to the production of the same evidence. I am therefore satisfied that the prosecution established the element of penetration to the required standard. As regards to the identification of the appellant, there is no doubt that PW3 was victim and the only eyewitness of the offense, as in the case of most sexual offenses. In her evidence before the trial, the court, PW3 gave a detailed and consistent account of what the appellant did to her, and she called for help and called for him when he called her to his house. She also stated that the appellant was known to her as Pastor Kanyari, since she had had other children whom she used to play with call him so. Further, I note that PW1 stated upon the appellant's arrest by the village elder Mataka that the next morning after the incident, PW3 was able to identify him as Pastor Kanyari who defiled her. She was able to recognize him even in court during trial. I also note that the trial magistrate had the advantage of observing PW3 and her demeanor firsthand as she testified and found her truthful. There is therefore no reason to interfere with the findings, which means that there is no doubt that the appellant was the perpetrator. Further, it was the appellant's submission that the prosecution failed to call crucial witnesses to testify in court. These were PW's husbands, Jackson, neighbor Monica, and Elder Mataka, Esther, who was playing with the PW3, and other children. Nyumba Kumi elders who arrested the appellant. So Kanyari was calling for other people to be called into the case to testify. Like he was forgetting that the person he had defiled had identified him positively. But he was looking for people for Nyumba Kumi to come and speak in court, which had nothing to do with him penetrating a minor. Like, because the evidence that was presented was based on medical records, but he was going around saying that he wanted the people for Nyumba Kumi. So it is well settled that the prosecution reserves the right to determine the number of witnesses it deems sufficient to prove a fact. I have carefully perused the evidence on record, and I am able to see the benefit that the evidence of the aforesaid witnesses would have added, since the 4 witnesses called by the prosecution sufficiently established the case for prosecution. In the upshot, I find the prosecution proved its case against the appellant beyond any reasonable doubt. His conviction was therefore and well-founded and is accordingly upheld. This was the appeal that Kanyari made. So lastly, okay, so the conviction, that was life sentence that was granted in the lower courts. Again, when he went to the Court of Appeal, his conviction was therefore well-founded. This is what the appeals court had determined, that his conviction was well-founded and accordingly upheld. Sawa sawa. In the present case, the record shows that the appellant was given an opportunity before the trial court to tender mitigation, wherein he stated, Kanyari the Mbakaji stated that he was 50 years old, married with children, and that his family was suffering because of the case. The trial court to the other noted that it had considered the appellant mitigation and the Supreme Court decisions of Francis Kariako Murate, but took into account that the offense was heinous and should be punished to deter would-be offenders. Okay? On the part of this court, I cannot add more, save to emphasize the court is unable to fathom how a 50-year-old man in the person of the appellant could have the audacity to defile a 4-year-old child. This is beastly. The injuries inflicted on this child shall remain a sour memory for the rest of her life. They have totally ruined her life. The least the courts should do to such persons is completely remove them from the society so as to cushion helpless children such beastly attacks. For this reason, I cannot fault the learned trial magistrate exercise of his discretion to impose a life imprisonment. This means that the appellant case was proper and is accordingly affirmed. Conclusion, according to the appeal, accordingly, the appeal lacks merit and is hereby dismissed entirely. It is so ordered. That is dated and delivered in Naivasha this 26th day of May 2022. G. Gwenye Macharia, judge in the presence of the appellant in person and styling as respondent. Sawa sawa. That is the evidence that you need. I've read the whole document. Go and download it. Meskia, Kanyari appealed the life sentence that was imposed upon him kwa kudefile mtoto wa 4 years and 6. When he appealed, his appeal was dismissed based on the evidence, and then the what was put there. He was supposed to be serving, he's supposed to be serving life imprisonment. Kanyari is supposed to be serving life imprisonment. That sentence still stands. So we want to know, the government of Kenya, ituambie hii kesi ilifika wapi? Kwa nini Kanyari yako nje? Ndio maana wanawake wajinga wako hapa wanamsupport. The judicial system is failing us. Nani, I know. And I'm going to make an appeal to Millie Mabona, Gladys Wanga, and all women legislators. Please, can you raise this in parliament? We need this. We want to know why Kanyari did not go to prison. We want to know why Kanyari is still walking free while the Court of Appeal dismissed his appeal. He was found guilty. There were medical records. Why the man is still walking free? Please, Millie Mabona and any other women legislators, please. Esther Passaris, tafadhali, all the people, Haki, Kenya, Amkeni, Africa, everybody. Okay, Amnesty International, please. We need to know why Kanyari is still out. We need to know why Kanyari is out. If we are going to mobilize women to go to the streets, we are going to do so. We are going to mobilize women to go to the streets in Kenya, in Nairobi. We are going to make sure we raid that church, and we are going to make sure we know why mtu ambaye alibaka mtoto wa miaka 4 akaenda mpaka appeals court na akapatwa kama bado ako guilty na kuna life imprisonment Kenya. We want to know why this man is still free today. We want to know why this man is sitting on a pulpit to brainwash women and children. We want to know why this man is being allowed to be near children and to even talk in public and sit with children, our little girls and boys, while he was found guilty in court. We want to know why Kanyari is free today. If the justice system lied to us, we want to know why this document is available online. We want to know why the court came up with this conclusion. We want to know that. Moving forward, we are not going to be negotiating. We are not going to be nice. We are not going to be happy. We are not going to wait and listen and watch a man mwenye alibaka mtoto aka take away the life of a 4-year-old girl in 2017 up to today. We want to know why Kanyari has not served his sentence. And that is the noise we are going to be making. That is the activism I'm going to be doing. People need to know that Kanyari alibaka mtoto wa miaka 4 na miezi 6 na akakuwa found guilty and he was sentenced to life. We want to know. We want to know where this baby is. We want to know where the parents is. We want to know where Monica is. We want to know what happened in Naivasha. We want to know if there were other victims, because it is stated clearly that Kanyari used to target children playing outside and he would call them and put them into his house. I believe this is not something that he did for the first time. I believe that if we continue doing research and digging more, we will find that Kanyari had targeted children more than just one. Can you imagine if you left the market or left work and you come back and find your neighbor telling you that your child who is 4 years old is walking abnormally? Imagine a 50-year-old forcing himself on a 4-year-old girl. Can you imagine? Can you imagine this man sitting on a pulpit to address us as nabii wa Mungu? Ati sasa kwa hivyo yeye sasa leo ni nabii wa Mungu, leo anakuja kutuambia mambo ya Mungu kama alibaka mtoto wa miaka 4 na miezi 6. And then the excuse that he gave the courts, that he is 50 years old, that he has a family, that his family is being destroyed, while he had wiped off the life of a 4-year-old. And you find women on this platform sitting down to discuss him as a man that they need to sanitize. Women on Kenyan TikTok sanitizing mbakaji ambaye alibaka mtoto wa miaka 4 na miezi 6. Mtoto ambaye alikuwa ameshindwa kutembea. Mtoto ambaye alipobakwa ile damu ilikuwa inatoka kiasi ambacho kilikuwa kinakuwa described as oozing. What a shame. Women sitting on a platform trying to sanitize this man. And Kanyari is now paying people on this platform to try and watoe uvumi na uchafu. Unasikia? To try and undermine what he has done. Kanyari atakuwa mbakaji jana, leo, kesho, mtondogo na kila siku. Nitamuita mbakaji mimi na sitaacha kumuita mbakaji. I will not stop talking about Kanyari and the case. We want to know. Kenyan women in parliament need to tell us why Kanyari hajapelekwa jela. Tunataka kujua what happened to the judicial system. We want to know why Kanyari is free today. We want to know why Kanyari was not taken to jail. We want to know why the welfare of our children is not prioritized. We want to know why tuko na mbakaji anasimama na ana preach mbele ya watu. Wacha ni block mbwa ingine hapa. What the heck? How did this dog come to my life? Hii mbwa imekuja kwa live yangu namna gani? Tafadhali moderators, can you block this decruise? Block hii mbwa. You block kabisa. Toa hii mbwa kwa live yangu. Kwenda na huko. How can we have mbakaji sitting on a platform talking to us about family, telling us how he's a good father? Hakuna mbakaji mwenye ni good father. There's no day. There is no day mbakaji atakuwa good father. And I've said it. And I've said it and I'm repeating it again. And by the way, there is a video of Kanyari holding the breast ya msichana wake. Sijui kama umeiona. Mumeona hiyo video akishika matiti ya Sky. Na wengine wenu mnasema there's nothing wrong with that. Some of you here have been saying there's nothing wrong with that. Unasikia? This is a man that has a history of kubaka mtoto wa miaka 4. Alafu kuna video yake anashika matiti ya msichana wake. Alafu nyinyi mko hapa niliona wengine tukiwa kwa platform ya Rising wakisema wanawake wenye wako na akili zao. Wanawake kwa hii platform, what's wrong with you? Mko na akili? Mko na akili zenu timamu? Mko na akili zenu ama nyinyi ni wajinga? Mmekuwa wajinga? Ati mko pale hivyo mnasema eti sioni kitu mbaya kama hiyo. Basi peleka msichana wako akaguzwe hivyo na Kanyari. Peleka tuone. Take your child. Who's this sending me nini? Stucky. Peleka mtoto wako akaguzwe huko tuone kama unaweza kubali. Let's see you accept that. Shame on you women that are supporting Kanyari. Hamna aibu. Sai wameanza kuita Betty super glue. They have started giving her labels. They are using bloggers. They are using people on TikTok to give Betty Bio labels. Listen, I've told you and I'm repeating again. If Betty decided that the home of Kanyari was not safe for her and she left, it is definitely not safe for her children. Kama Betty mwenyewe ndio aliamua pale sio safe for her, there is no way it is safe for her children. Betty knew that is why she left. If it was going to be a safe home for her, she would still be there. That's the truth. Betty left because it was unsafe for her. Betty left because she felt that her children did not need to be in that space. She felt it was not safe for her. There is no woman that goes away from a space that is safe for her. No way. She knew. That's why she left. And then there are women here who are talking about Kanyari being the biological father. That's bullshit. The fact that you're the biological father of the children does not mean anything. Mtoto ni kulea, sio kuzaa. Mtoto ni kulea, sio kuzaa. There are so many parents that lose their children.